Twenty-six CR 598 is called the State of Texas versus Billy Wayne McClain. This is in 26 CR 598, a first degree felony of burglary of a habitation. And then in 26 CR 599, illegal possession of controlled substance. All right. Look at this. This is in the file here. Appears to be a handwritten document that the defendant writes, asking for a mental evaluation. Yeah, those things. Do you know that? Anything about it?
I don't know anything about it, but I've visited with him multiple occasions. I don't see any cause for the mental examination.
What do you say?
He knows what he's doing.
Is that right?
You know what you're doing. So.
So this, you're withdrawing this request for a mental examination, are you? You have to speak out so she can hear you. What are we going to do, Don?
Please, Your Honor.
Where are we on this? He's good?
No, that's what she.
Let me see. Yeah. Shame on you. Where is it? You? Shame on you. You're testing positive for methamphetamine and amphetamines. That pretty much explains everything. Shame on you. You're on this court. What's his bond?
Hang on. 15,000.
Your bond is revoked. It is $50,000. Plus, you must have a GPS device so I know where you are when you're getting your drugs.
Yeah.
And also, you need a drug patch so I know if you're using any drugs illegally at any time. Shame on you. This is a serious crime, and you're caught. This is a felony offense. We just caught you at another felony. Shame on you. You're taken into custody. That's the orders of the court. One gets out, goes from one mess to another, just more serious. Shame on you. Which one is he pleading to?
Both cases, Your Honor.
All right, you are Billy Wayne McClain. You're going to start, and you understand what you're charged with in each of these cases?
Yes, sir.
Does the defendant waive formal readings of indictments and arraignments here? Can we proceed in summary?
Yes, sir.
In summary, 26 CR 598 alleges, and are we going on just paragraph one?
On this file.
Paragraph one, it states that on or about October 10th, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. And that is entered a habitation without the effective consent of the owner with the intent to commit the felony of sexual assault of a child. Do you understand what you're charged with here?
Yes, sir.
Do you understand what you were charged with here, sir?
Yes, sir. Yes, sir. Both of them.
This is a first degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand
Yes, sir.
the punishment range applicable for this offense? An agreement's been reached where you would be pleading guilty and sentenced to 40 years in prison. Is that right?
Yes, sir.
To run concurrently with the other case, 26 CR 599, let's see. The state jail felony of illegal possession of a
It
controlled
is,
substance.
but it's enhanced to secondary punishment because of priors.
You got a prior aggravated sexual assault of a child in 2001 conviction from the 252nd District Court of Jefferson County. After that was final, you committed the third-degree felony of harassment and were convicted of that in the 320th District Court of Potter County, Texas in 2010. Okay. So back to this 40-year sentence. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily?
Yes.
That is on your own free will and because you are guilty.
Yes, sir.
Going to hold that one in abeyance. And for a moment and go to 599. And the defendant waives a formal reading of this indictment and we can proceed in summary.
Yes.
In summary, paragraph 1 of this indictment alleges that on or about March 17th, 2025 in Jefferson County, Texas, you committed the state jail felony of illegal possession of methamphetamine. You know, understand what you're charged with here? Paragraph 2 goes on to allege that you were convicted on February 12th, 2001 of aggravated sexual assault on a child in the 252nd District Court of Jefferson County, Texas. Is that true and correct as it is alleged in that cause number 77436? And are you pleading true and correct to that voluntarily and because it is true?
Yes.
And paragraph 3 goes on to allege that after that aggravated sexual assault on a child conviction occurred and became final, you committed the offense of harassment, a third-degree felony, and you were convicted of that felony on February 22nd, 2010, in clause number 55528-D as in dog, in the 320th District Court of Potter County, Texas. Is that true and correct as it is alleged? And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Do you understand that voluntarily and knowingly made pleas of truth to paragraphs 2 and 3 of this indictment is enough to enhance this state jail felony to a state jail felony, though it will be punished as a second-degree felony because of the prior convictions? Do you understand? Yes. That means you are facing, in this case, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And in this case, the agreement's been reached, or you would be pleading guilty, sentenced to 20 years in prison to run concurrently with the preceding first-degree felony of burglary of a habitation at 40-year sentence. Do you understand how that will apply, and is that what you understand?
Yes, sir.
If I follow this agreement as well, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Well, I'm going to try to raise this awkward device.
Want me to see if I can get it, Joe? Today, I don't know what's going on.
Do what?
They're like they're lagged differently today. Oh my God, right. So.
I can see. Hold on. All right, once again, how do you plead in cause numbers 26-598, the first degree felony of burglary of a habitation, and 26 CR 599, the illegal possession of a controlled substance, guilty or not guilty in each case? Are you pleading guilty voluntarily and
Yes, sir.
because you are guilty, sir?
Yes, sir.
And in 26 CR 599, the state jail felony of illegal possession of a controlled substance, are you pleading true to allegations 2 and 3, those prior convictions of aggravated sexual assault and harassment as alleged in that indictment? Are you pleading true and correct to that voluntarily in each case and because those allegations are true?
Yes, sir.
And do you understand by doing so, if the court finds you guilty, which I'm going to do in this particular case, that this constitutes a state jail felony, although it is punished under law as though it were a second degree felony?
Yes, sir.
I showed you in each case what's marked as State's Exhibit 1. Did you sign those documents,
Yes.
understand them, discuss them with your attorney,
Yes,
or the contents are true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in
No
each
objection.
case without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments that have been read to you, you've read them. You were guilty of each of these crimes in 26 CR 598 and 599. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports are waived in each case?
Yes, sir.
I'm going to follow these agreements and find in each of these cases you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Is there sufficient evidence supporting your guilty plea in each case because of State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt in each case? In 26 CR 598, the first degree felony of burglary of a habitation, you are hereby found guilty of that offense as alleged in the indictment. I am following that agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And that's, and the indictment and the records will reflect that, burglary involved the intent to commit a felony offense of sexual assault of a child. And in 26 CR 599, I hereby find you guilty of this state jail felony, but also paragraphs 2 and 3 have been proven true beyond a reasonable doubt, which constitute a state jail felony, punished as though it were a second degree felony. And I find paragraphs 1, 2, and 3 true and correct. And you were found guilty of those 3 allegations, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years in that case. These sentences shall run concurrently. Do you understand what has happened in each of these cases, sir?
Yes, sir.
Anything else? That is all. That's all.
On that one.
All right, we are looking at two cases here, 26 CR 852 and 853, the state of Texas versus Eric Lee Norman. And that's you, sir?
Yes, sir.
And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments in each of these cases? Can we proceed? So,
Yes.
okay, on 852, this is a state jail felony punished as though it were a third degree felony?
Yes, sir.
Correct?
That's correct.
Okay. In summary, 26 CR 852 alleges that on or about January 7th, 2026, in Jefferson County, Texas, you committed a state jail felony of credit card or debit card abuse. Do you understand what you were charged with?
Yes, sir.
Paragraphs 2 and 3 go on to allege, though, that on January 12, 2018, in this criminal district court of Jefferson County, Texas, that you were convicted of the state jail felonies of theft and cause number 13-17219, as alleged in paragraph 2 of this indictment, and the state jail felony of burglary of a building in cause number 13-18271, as alleged in paragraph 3 in this indictment. Do you understand what you are charged with in paragraphs 1, 2, and 3 of this particular indictment?
Yes, sir.
And this constitutes a state jail felony, as alleged in paragraph 1. But this alleges paragraph 1 that on or about January 7th, you intentionally used a debit card knowing it was without the effective consent of the cardholder. That constitutes credit or debit card abuse, a state jail felony. But paragraphs 2 and 3 do constitute a state jail felony, but it's punished as though it were a third degree felony because of the 2 prior convictions as alleged in paragraph 2 and 3. Do you understand that, sir?
Yes, sir.
Which means you were facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case with you be pleading guilty to 6 years imprisonment for the state jail felony, punished as though it were a third degree felony. This sentence will run concurrently with the agreement in 26 CR 853, that state jail felony we will be going into here in a minute. Is that your understanding of the plan?
Ran concurrent with the other,
The other charge, the other state jail. That means they'd run together.
which other part? I'm already doing 6 years.
I don't know what you're doing.
Yeah, the 2 cases today, you'd be 6 years concurrent.
Concurrent with the other cases?
Yes. Yes, everything's on current.
Oh,
Is that your understanding of the plan?
yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
In each case.
Yes, sir.
Hold on, I'm trying to. We are getting a substitute for this device, right?
Yes, sir. Okay.
It wasn't made for a human to use. I don't know what they used as they go by, but you can't, the finger has to depress 2 devices and they're separated. Your finger isn't big enough to hit them both at the same time.
Yes.
As I'm explaining it.
Take your time.
Thanks for bearing with me.
Yes, sir.
Okay. If I follow these agreements, sir, you have no right of appeal in each of your cases. Do you understand?
Yes, sir.
All right, so let's get to the heart of the matter in each of these cases. In 26 CR 852, how do you plead to paragraph 1, alleging the state jail felony of credit or debit card abuse, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, alleging those prior convictions on January 12th of 2018 that we went over, state jail felony of theft and a state jail felony of burglary of a building out of this criminal district court of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct with those voluntarily and because they are true as they are alleged?
Yes, sir.
And in 26 CR 853, how do you plead to paragraph 1, a state jail felony of theft of property, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges in 2016 in this criminal district court of Jefferson County, Texas, you were convicted of theft. And in 2018 in this criminal district court, you were twice convicted of theft cases on that date. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations in paragraph 2 voluntarily and because they are true as they are alleged?
Yes, sir.
And that constitutes a state jail felony. So you've got a state jail felony punished as though it were a third degree felony in 852, and in 853, you have a theft case, which would have otherwise been a misdemeanor, but because you have 2 or more prior theft convictions in felony court, each time you steal a pack of gum, it's a felony offense from here on. Do you understand?
Yeah, yes, sir. No, that's
Best to be honest.
Yes, sir.
You don't have to worry about things. I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney?
Yes,
Are
sir.
the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each case
No objection.
without objection admitted. Among other things, the state you are mentally competent to enter your guilty pleas today. They are freely and voluntarily made. You know what you've been charged with, and in each case you are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 was made a part of the record for all purposes. Help me out here. What am I missing on this? On 26 CR 853, the paperwork shows a third degree felony. How is it doing that?
Because of the 2 prior ones.
I know, but the allegation 1 is theft of less than $2,500. That would be a misdemeanor, wouldn't it?
No, it's state jail.
Is it?
Well, so with the 2 priors and then after that, the prior. So there, I don't know what it is. Let me see. Jimmy's fit this.
Your Honor, I got 7 months already.
Hold on. Hold on. Yeah, this is,
Enhanced.
yeah, this is a
State jail, and you've got 2 prior state jails.
This one doesn't have the 2 prior pages of those.
No.
Hold on.
I don't know what they are, actually, but they're.
Hold on. Yeah, but those are just thefts. You can't do that. You can't enhance it with thefts. On thefts. So, you can't do that sentence that he has. He should have alleged these burglary of them.
But it is a state jail felony, isn't it?
Well, there's two tests.
It's just not a third degree felony.
It's not third degree, it's a state jail.
Okay, y'all gotta write up the papers for.
Yes, sir, we're gonna have to change the offer. Because it can't be 6 years.
Well, no, the first one was 6 years.
Yes, but the second one can't be, it's only state jail felony.
Yeah, 6 years, that can't be.
So I don't know how,
It's gonna have to be a state jail, so it can't be more than 2 years. So you're getting a benefit here. They're gonna have to redo the paperwork.
Judge,
We're
since
gonna come back.
it's not gonna enhance anything later on because we've already got enough state jails, I'll just dismiss that one. The state jail.
Oh, okay. So 26,853, you're just gonna dismiss.
Yeah, it's not gonna enhance anything later on, it's not gonna help anything, hurt anything.
Okay,
I'll take
hold
care.
on. Hold on.
Yes, sir.
We got a victim here. Whatever's gonna happen, this victim is not standing out in the cold with a loss of something that the defendant would have been otherwise responsible for, correct? We got a victim here.
In the offense report, they did say there was $115 loss, but they have not sent anything back to our office requesting us to collect their restitution for them, so.
Okay, so then you're gonna send me a dismissal on
Yes, sir.
853.
Yes, sir.
On 26 CR 852, that's what we're standing by. That one will go forward. You have pleaded guilty and to paragraph 1, voluntarily, knowingly, intelligently, and to paragraphs 2 and 3, you have pleaded true to those 2 prior state jail convictions. This is, and there's enough from State's Exhibit 1 to find you guilty beyond a reasonable doubt. This constitutes a state jail felony, punished as though it were a third-degree felony. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 6 years on that case. You understand what has happened today, sir?
Yes, sir.
All right, anything else?
No, sir.
That is all.
Thank you, Judge. Thank you.
Then the 8 wasn't me. I'm taking it.
Yep.
That way I can do the dismissal.